Hi, warriors. This is Jaylyn, my legal warrior. And today's segment is going to be catered to parents or spouses that are in agreement about their divorce case and they just want to plow through this coronavirus. They don't want it to hold them back in terms of reaching an agreement. And so they are ready to prepare their divorce packet so they can submit it to the courthouse. Now, word on the street is that the court is not really accepting those documents at this point in time. I've heard various things from different attorneys that they submitted documents but haven't received them back. So who knows if they're actually receiving the documents, whether the court is actually receiving the documents. But at this point in time, it's best to just prepare the documents while there is an agreement in place between you and your spouse. And when the courthouse is open, hopefully on April 6th of 2020, then that's one of the first things that you do is drop off those documents at that time. So I wanted to show you what documents you and your spouse needs in order for you to finalize your divorce. These are the last set of documents that you will ever need in your divorce case, absent any issues after your divorce has been entered. And when I use the word entered, I mean finalized. That the court actually, or the judge or judge signed off on your agreement. So I wanted to share with you the documents. And so this is straight from the San Diego County Superior Court's website. And as you can see, it has all the forms that's included, as well as some optional forms if you do have children. So if you do have kids, then there is, well, if you have kids, this is what you're going to also complete. But if you don't have kids, you're just going to complete the first half of this. So it says the judgment checklist, and this is very helpful. Even as an attorney, I use this all the time with my clients just to ensure that I do have all of the documents. And I always submit this checklist for the clerk. If there is no response from the other party, meaning there's no responsive paperwork that was filed by the other party, but you two have come to an agreement, then you are going to file the default with agreement. You're going to go ahead and check off this box because that is what you and your spouse have agreed to, is that he or she doesn't need to respond to the action in court, but they do need to submit their signatures on this written agreement between the two of you. So you want to make sure that you have all of these documents from the FL-115, the FL-165, your FL-141, and then one of these three, whether your written agreement should have the information that's required to waive your final declarations of disclosures or to show that you've prepared your final declarations of disclosures. One of you needs to prepare the declaration for default. Usually that's the petitioner that prepares it. Actually, almost always the petitioner is the one that prepares it because they're the only one that initiated the action. They're the only one that's participating in the action, and the other party's only participating for the purposes of this written agreement. So the declaration for default or uncontested dissolution or legal separation should also be completed. Obviously, your written agreement, and it has to be notarized. And I'm so glad that it is on this form. It says the respondent, which is the other party, their signature on the agreement has to be notarized, okay? The court's not going to accept it if it's not an original signature and it's not notarized. So you please make sure that the other party is providing you notarized documents. And then the judgment cover sheet, the notice of entry of judgment, and then make sure that you provide the two-stamped envelope. It's going to allow for the court to return all the documents back to you. If you don't provide those, then the court's just going to leave it at the courthouse. And maybe if you're lucky, you're going to get a call from one of the clerks saying, hey, we processed your judgment, but we can't return this to you. What do you want us to do with it? And typically you would get those phone calls if you are an attorney, but if you are not an attorney, then you are likely not to get that phone call, and maybe they will write you some sort of rejection letter stating that they don't have the stamped envelopes from you. So you need to make sure that you have 3 envelopes, not just 2, 3. 2 envelopes is going to be for the notice of entry of judgment form, and then 1 envelope is going to be for the judgment packet. Okay. It says here that you should have an additional envelope that goes to the respondent, but typically the way that I do it is that the 2 stamped envelopes, one is for the notice of entry of judgment so that each party gets the notice of entry of judgment, and then 1 envelope so that the paperwork comes back to my office and then I distribute it to both my client and the other party. So if you do have kids, then you additionally need to fill out the rest of these forms. So you need to make sure that your FL 105 is up to date. If it is up to date, no need to file a new one. Your income and expense declaration is needed unless there's one that's been filed in the last 90 days and there's been no changes since then. You need to have the printout of your guideline child support, but you don't really need to have the printout, but at least the income information, the deductions, all those factors that go into completing the child support guidelines, into calculating the child support guidelines, that needs to be listed in your written agreement. So if you don't have it in your written agreement, then you do need to print out this guideline child support. And then it has notice of rights and responsibilities. You just go ahead and attach that to your agreement. It's a standard form. Make sure both of you read it because it's very important as to how you each can collect out-of-pocket costs from the other if it is supposed to be split between the 2 of you. And then if you both are under an agreement for child support, then you would complete one of these 3, whether it's a written agreement or filling out one of these forms, the 350 or the 342. And then if you want to garnish the wages of the other party, this is a great time to go ahead and complete it. Even if you don't use the income withholding for support form, like you don't actually submit it to the other party, but it's always nice to have, because maybe down the line your spouse or the parent of the other child does not in fact pay the support, and then you're having to file this form when you need to now wait God knows how long until you receive it back from the courthouse. So it's always best practice to submit this form with your dissolution, and if you do need to submit it to the employer because the other party is not paying, then you can go ahead and do it right then and there versus waiting. And then the last thing is the child custody visitation attachment, or it's going to be within your written agreement. So again, this is a default with no response, which means that the 2 of you have an agreement with one another and the other party has not filed their FL 320. Lastly, the 3rd type of divorce packet is an uncontested case. So if you have an uncontested case, this means that the response has been filed. The FL 320 has been filed, or the other party has filed something in the case. Maybe they didn't file an FL 320, but they went ahead and filed a motion for child support or a motion for child custody. By them filing that document, it means they've made an appearance in the case. And you 2 have now reached an agreement. So if you 2 have an agreement, you would go ahead and fill out all of these forms. The respondent, the other party, must actually pay the $435 in order for the court to process their dissolution packet. So unless there's a fee waiver, or as it states here, your active duty military, the court is not going to allow you to process your judgment with the agreement unless the other party has paid the $435 or obtained a fee waiver or their active duty in the military. So the declaration of disclosures must be completed. Your final declaration of disclosure either must be waived or within your agreement. The declaration for default, either one of you can complete that, but most of the time it is the petitioner that does complete this. And then the written agreement, your judgment, the proposed copy of your judgment, the notice of entry of judgment, and then the 2 stamped envelopes. And so with the 2 stamped envelopes, again, it's sufficient size with sufficient postage to return the judgment and the notice of entry of judgment. And really, I've never received the judgment and the notice of entry of judgment in the same packet. They're always provided back to me in 2 separate packets. So I submit 2 envelopes and I attach it to the notice of entry of judgment so that when they process it, I get a copy and the other party gets a copy as well. And then I have one large envelope with sufficient stamps so that the copies of the conformed copies, the processed copies, the final judgment is also returned to me. All right, and then if you have kids, it's the same thing. You fill out the same forms. The UCCJA, the FL 105, whether you have a guideline child support calculation that you need to print out, you need to make sure that these notice and rights and responsibilities are there. One of the child support orders must be there. The income withholding order, you have the option to complete that too. And then child custody and visitation attachment, or just have the written agreement. So this is the best checklist that you can possibly go off of to ensure that you have everything necessary for your dissolution of marriage. And all the forms are in this packet. So you can print it out or just complete it right on here, go into the sandiego.ca.gov website, and you can always review the rest of this packet on your own time. If you do find this to be helpful in any way, then please share, please contact your contacts by sharing all of this, because you never know who may actually benefit from this sort of information. Thank you so much for your time, and we hope that you are staying safe warriors. Thank you.